首先祝大家新
Members, I wish you a very happy and healthy new year. And I wish everything well at LegCo. We now have a quorum. And we can get started with the meeting. Information papers issued since the last meeting. Since the regular meeting on the 22nd of January, the panel received one information paper, and details are listed in item 1 of the agenda. The panel also received a letter from Dr. Junius Ho requesting a discussion on the prosecution policy for criminal corruption cases, as well as the collaboration relationship between the Department of Justice and the ICAC. The letter has been tabled. Do members agree to incorporate this item into the list of outstanding items for discussion? Does anyone wish to speak? Dr. Junius Ho, please be brief. Thank you, Chairman. My late was rather late. For the on the donations scandal, I have mentioned the details in my letter, and there's general interest over the incident, and after 3 years of investigation, they are interested about the outcome. So the objective of my letter is for the DOJ to offer more detailed reasons. They cited a lack of evidence earlier. Generally, I understand they would not disclose details, but I have read the guidelines on prosecution, and there are certain exceptions. So I hope that this can be discussed at the AJLS panel. Does any other member wish to speak? Vice Chairman, I'd like to thank Dr. Junius Ho for raising this issue on prosecution. For criminal prosecutions of public interest, the DOJ needs to make an explanation, just like the $50 million sum received by C.Y. Leung. Recently, there were rumors that the DOJ would not make prosecutions, but subsequently it has been clarified that it wasn't the case. Indeed, the DOJ cannot refuse to offer an explanation on the grounds that they would not comment on isolated cases. So I do agree with Dr. Junius Ho, and we should invite the Secretary for Justice to make an explanation, as well as the $50 million sum received by C.Y. Leung. Does other member wish to speak? Dr. Loh Wai Kwok. I think the issues mentioned by the Chairman and Vice Chairman are all matters of public interest. I would not mind that they be discussed here. Ms. Alvin Young, I generally agree with the Vice Chairman, but I hope that we can establish certain standards at the panel for are we going to discuss items of members' interests in the future, or should DOJ provide the standards? They should have explained the matter before even being invited by LegCo. So what are the standards? And what would be the standards of the AJLSP? Would we resort to voting, and would voting be the best practice? So I hope we can establish a system here. Does any other member wish to speak? As for the prosecution policy, I have reflected members' views to the DOJ. They were not prepared for the relevant discussion item yet. As for the views of Dr. Junius Ho and other members, I have taken note of them. Generally speaking, for matters within the ambit of the panel, they are focused on policies. This is certainly directly related to the prosecution policy and the administration of justice and legal services. As to when it can be included on the agenda, as you know, I've already been communicating with the DOJ on future meetings and the agenda, and we have something sorted for the next few months. As to whether we will have a separate item on prosecution policy, today we are talking about the briefing out system, and this could be somewhat incorporated into various agenda items, so members are free to offer your views. Many members are interested on this item, so I would include it on the list of outstanding items for discussion. So we shall await the DOJ's reply and schedule. This item was included before, but it's yet to be included on the agenda because we must wait till the DOJ have enough information. So we will certainly follow up on that. Barring any other comments, let's move on to the items for discussion for the next meeting. Members, please take note of CB brackets 4619/17 to 18 brackets 01, list of outstanding items for discussion. And the second, CB brackets 4619/16 to 17 brackets 02, list of follow-up actions. We have been following up on a number of issues in recent years, and some of those are pending a report at the Council by the fourth quarter. The date of the next meeting will be the 26th of March. The first item would be future development of the legal profession under the trend of globalization, its impact on the legal profession and legal services to the public in Hong Kong. Apart from invitations extended to the two legal professional bodies, on this issue we will see whether any law schools or deputations might want to share the expertise here. The second item to be discussed next time will be mainland judgments in matrimonial and family cases, reciprocal recognition and enforcement bill. Please refer to the second item on the list of outstanding items. Do members agree with the discussion of the above two items? All right, we now enter the agenda proper. From the DOJ, please. And we also invite representatives from the two legal professional bodies. Item 3 of the agenda, briefing out of criminal and civil cases by the Department of Justice. And we are looking at CB brackets 4619/17 to 18 brackets 03. And CB brackets 4619/17 to 18 brackets 04. This is a paper prepared by the Electrical Secretariat. Members who wish to speak, please press the Request to Speak button or raise your hands. We first invite the administration to walk us through the paper before we invite Mr. Philip Dykes, Chairman of the Hong Kong Bar Association, and Mr. Randy Shek, representative from the Hong Kong Bar Association, to offer their views on the item. The Law Society has not sent any representatives on this agenda item. And I'd like to report that the Law Society submitted a written submission. They actually had 2 submissions. And they hope that the administration could share the papers as early as possible. But since we just had the Chinese New Year, they actually requested papers to be submitted 21 days ahead. And this time, the government failed to meet such deadline. And a deadline of 21 days before the meeting might not be realistically feasible. So hopefully the DOJ would acknowledge that. They hope that papers should be shared 3 weeks ahead, and we will certainly do our best. But please understand that things might happen at short notice. So I hope everyone could understand the situation.
Next, we ask the legal Department of Justice, will it be Ms. Christina Zhang, law officer, civil law, or Mr. David Lau? Perhaps I will start. We are very glad that the panel has invited us so that we can brief you on the briefing out arrangement and related matters. Now, earlier, we provided a document on the briefing out policy, the fees, and selection of lawyers, and the factors to be considered. So detailed information has already been provided. But I'd like to highlight a few points. Firstly, the briefed out cases is mainly to meet operational needs. Now we have not set up a proportion of internally handled cases and briefed out cases, and we have provided relevant details in paragraph 3. And the annual expenses of briefing out varies from year to year. It depends on the complexity and progress of cases, and these factors are not completely under government control. Now, the expenditures for different years should be compared on that basis, taking into account those factors. Now, the DOJ follows internal guidelines for briefing out, and the selection of counsel is also on that basis. For the standard briefing out cases, which are criminal cases, these are assigned in turn. non-standard cases, including criminal and civil cases and construction dispute cases, we would first consider taking into account the nature and complexity of the case to see whether the work should be briefed out. And if the need is established, then we would consider the seniority, experience of the counsel and whether they have the expertise required and the level of the fee charged. Now, as for appointing local senior counsel or overseas counsel, we are very careful to ensure that the briefing out is only on the basis of need, given the nature of the case. Now, we take into account the ability of the counsel concerned. Prosecution is very important. The prosecution department attaches all the more importance to the ability of the counsel concerned. So I'd like the Director of Public Prosecutions to brief us on that. So, Mr. Leung. Now, enhancing the capability of the prosecutor is an important part of our work. Now, for our prosecutors, we increase the manpower. We also want to let the prosecutors to have more opportunities to handle more cases. And when these new prosecutors have accumulated enough experience, we arrange for them to attend short overseas courses. And since 2011, we have cooperated with the Law Society and Bar Association to hold training courses and the DOJ has provided opportunities and we pay nominal fees for them to work alongside experienced senior counsel. And the Public Prosecutions Department will continue to work with the two law groups to continue to try to raise the capability of these junior lawyers so that they are well trained alongside more senior counsel. Now we invite the chairman or representative, Mr. Philip Dykes or Mr. Randy Scheck of the Bar Association, either one of them, to comment to us.
I come with Mr. Scheck, and I'd rely on him when it comes to discussing briefing out in criminal matters particularly, but I have some general observations to make about the issue of briefing out.
Yeah.
I was
also sorry, Mr. Dykes, maybe you need to be closer to microphone. Yeah, thank you.
Yes, like this. No, I was begin by saying that I was disappointed when I looked at the Department of Justice website to try and find out how I would apply and how I'd be rated if I wished to become a counsel that was had the beneficiary of briefs, either civil or criminal. I contrasted that with the website of the Crown Prosecution Service in the England and Wales. And that website sets out clearly the criteria which it expects council to achieve, how they get on a list, how they progress on the list, what happens if they're doing well, they may be promoted, or if they're not doing so well, and how they may be held back. And there's a transparency about briefing out to the bar there, which is consistent with the fact that this is public money that's being spent, and the Crown Prosecution Service must justify selection as value for money. So I would like to be assured, if it can be done, that, for instance, that the DOJ selects counsel who are best qualified, but also regardless of ethnic origin, gender, marital status, sexual orientation, political affiliation, religion or disability. These are stated in the Crown Prosecution Advocate Panel Scheme for 2016 to 2020. Likewise, as far as civil work is concerned, you can refer to the website of the Attorney General, who says how he selects Treasury Counsel, what they are expected to do, what specializations people are encouraged to put forward for consideration. And likewise, the Attorney General says he will consider and appoint, I quote, the best candidates solely on merit, irrespective of age, ethnic origin, gender, marital status, sexual orientation, political affiliation again, religion, disability, or the chambers at which they practice. Because certainly as far as a civil briefing out is concerned, there's a perception at the bar that only very few chambers are the beneficiaries of briefing out. That's a perception which should be dispelled. So to sum up, I'm quite sure that the DOJ conscientiously briefs out the work according to its criteria, but there is room for making the criteria, not necessarily all criteria, but selection criteria open and public, so that barristers may say, I can do this. I'm going to make an application, it will be treated appropriately, and if I'm accepted, I can have a certain career progression. At the moment, it all seems a bit of a black box. Now, I'll defer to Mr. Sheck as regards to the specifics of criminal briefing out.
Okay.
主席多謝。
Mr. Sheck.
主席多。
Chairman, I'm thankful that we have the opportunity to reflect the Bar Association and the profession's views on briefing out. Now, first, the briefing out work is at three levels: magistrates, DC, and at the High Court level, and for junior lawyers, they value this opportunity. They can practice their litigation skills, and of course, they earn income from it. Now, for counsel in private practice, very often they do defense work. If they have the opportunity to do prosecution work, it's helpful for the entire process. So the defense counsel understands what work has to be done by the prosecution side. So this is helpful for the entire trial process. Very often, now when briefed out counsel is doing the prosecution work, Now, they compare well with many prosecutors in the courts because many of them don't have law degrees. They didn't have the same training. So when it comes to controversial issues, trained and qualified counsel doing the prosecution work is a great help for the manifestation and the realization of justice for the council, it's also good. Now, and we understand that at DOJ, especially at the magistrates courts, they do have the need for the briefed out counsel to handle the cases. And we also see some problems, however, in the structure. For instance, there many barristers, even with 8 or 10 years seniority or experience, now are also on the list of briefing out at magistrates courts. And some of my peers tell us that they have done 6 or 7 years prosecution. Congratulations, you have just passed your probation. Now, a barrister starting at the low level of courts doing prosecution work. Now, how many years of experience is required before they can graduate to DC prosecution work? And how many years more for high court work? And we've heard that judges mentioning that at DC or HC very often they see the same group of people doing the work. These people have worked many years, but why are there no new faces? And so we hope that there will be a transparent structure at DOJ so that we know what time and what qualifications and experience are required before one can undertake prosecution work at DC and HC. So that will be a big improvement if we can do that.
And the second question is, how do we select the counsel for prosecution work? At the magistrates' courts, the DOJ has a roster, as far as I know. So if it's your turn, you will receive a call. And currently, there will be a call on average every 4 to 6 weeks. And at magistrates' courts, there are prosecution officer 1 posts, and they would help carry out prosecution work. Some barristers might receive 2 or 3 calls a month. So that's why some people might wonder why some counsel would have a lot of calls while others will have to wait 2 or 3 months for a call. So on the selection of counsel for prosecution work, there are calls for greater transparency, and they would like to know how the DOJ selects counsels. As for prosecution work, for junior barristers, there would be a 1-day training arranged by the DOJ before a 2-week placement, and the barrister would carry out prosecution work at magistrates' courts for 2 weeks, so they can put their knowledge into action. And the DOJ can also assess the performance of these junior counsel. And after this period, whether or not the barristers perform well in prosecution work, there is no feedback at all. some magistrates would comment on the performance of the more junior counsel on their prosecution work. Sometimes barristers would feel helpless even though they are somewhat experienced already, and their only option is to ask their colleagues in the law firms. So feedback should be given to the more junior fiat counsel, for example, those who have only worked 2 or 3 years. For the more experienced ones, they can still learn something. So we hope that the junior counsel would have a chance to learn, but we do understand that the court is a solemn place and there could not be too much room for or margin of error which might lead to errors. Some magistrates feel that some junior counsel are not performing well, so the DOJ and Bar Association can work together to do more by way of training and otherwise. Finally, I'd like to talk about the fees. Currently, the fiat fees are similar to duty lawyer service. For counsel in private practice, there is a very big gap in the fees charged. We realize that there is a review every 2 years, but what are the criteria being adopted? I believe that this deserves some attention. For barristers who prefer civil work, they might not want to take part in prosecutions. And for barristers that are already involved in this area in private practice, they might not to take part in prosecutions, and especially if the fees they receive are a lot less than that in private practice. So if the DOJ can encourage more experienced and capable counsel to take up prosecution work, the DOJ can certainly achieve its objectives more easily. Thank you very much for your views, Mr. Shek. After the meeting, I wonder if you can provide a written gist of the views so that we can reflect them to the DOJ. You gave some very good views, so please consider giving us a summary in writing. 5 members are waiting to speak. We have 6 now. We spent some time at the beginning discussing the agenda, so I'd like to give 5 minutes to each member, including question and answer. First, Mr. Elvin Yang, Dennis Kwok, Loai Kwok, Eunice Yung, myself, and Holden Chow. Ms. Elvin Yang. Thank you, Chairman. Chairman, I have a few questions for Mr. Leung. As I know, well, as suggested in the paper, for cases that are complicated or concern public interest, they would be briefed out to fiat or overseas senior counsel, and very often legal advice would be sought beforehand. So for cases of public interest or concern, had the DOJ ever rejected the external legal advice received, and are there relevant records? Mr. Leung, I would take this question. Thank you very much. First of all, the legal advice sought would be subject to LPP protection as to whether the legal advice provided by local or overseas counsel is accepted. Well, I have to look up the records, and it would be difficult to disclose such legal advice because of LPP, and there is protection under Article 63 of the Basic Law. In the past, in cases of major public interest or controversy, if no prosecution was taken for the sake of public interest, we would often explain the reasons for not taking out prosecution. And we would mention that legal advice was sought, but we, as I remember, we never talked at length about any inconsistency, etc. Thank you very much. In some cases, if no prosecution is taken out, well, if you take out prosecution, then you would have entered criminal proceedings, and it's in the hands of the courts. But if no prosecution is taken out, that would often lead to doubts. And Mr. Leung explained that the government would explain the rationale behind certain decisions for cases of major public interest, or if the persons involved are very important people. Is there room that after deleting certain sensitive data, the information can be partially disclosed? I think this would help with the credibility of the DOJ and the SAR government as a whole. So I'd like to see if there's any room for that. Mr. Leung, thank you very much. I cannot say across the board that there is or isn't room for that. It would depend on the cases. But as Mr. Young rightly said, if no prosecution is taken, we would disclose what can be explained. We would try to see to offer more details as possible for issues of major public interest. In paragraph 9, when hiring local or overseas counsel, there would be a number of factors to consider, and one of which is the candidate for the counsel or legal representation of the opposite party. But I would understand this as a lawyer, but I'd like you to explain this to the public. Thank you very much. Very often, we just want to assist the courts. If a case involves multiple SC overseas, we would try to appoint a comparable legal team to assist the courts. Mr. Nesquak. I have a question about civil proceedings. Civil proceedings are an important source of work for junior counsel, and it is a great training ground as well. So for civil proceedings, how do you select briefed out counsel or senior counsel? For briefed out civil counsel, do you have any records on the law firms or Director? The question was about the briefing out of civil cases. Civil cases cover a very wide scope, and depending on the complexity of cases, the experience or expertise required of fiat counsel would be quite different. So when selecting counsel, unlike criminal cases, we would adopt a non-standard briefing out model based on the needs of the cases. And there are two aspects to that. For more complex cases, if we are to appoint overseas senior counsel, we would identify a certain area of expertise of the SC. For example, if a case involves human rights or constitution, or if we need to appoint a certain counsel on the grounds of continuity, and for cases that involve appeals at the Court of Appeal or higher courts, well, I understand that. How about the association or law firm appointed? As we explained, we would not identify certain law firms, but you would have you should have statistics on the law firms of the counsel you appointed, which I'm talking about the chamber. I've been asking this question for a number of years.
No, if we do have these figures, we can go back and look at the records to see if we can compile them. You undertake you will provide them? Yes. We'll see if we have the information and we'll come back. So please supply with a written paper. Now, on criminal litigation, there have been training schemes over the past few years for young counsel. Now, how many went through the scheme and then took up fiat work for DOJ? Do you have such figures? Now, having completed the training, as Mr. Shek mentioned, which is a one-day training, if the barrister attains a certain standard, then he can undertake a 2-week prosecution assignment. Now, after the 2 weeks, if he doesn't attain a certain level, then he has to come back and attend classes again. Now, I just looked at the figures provided by my colleagues. Now, in 2016, we have this training twice a year, and the total attendees number 98. Now, after the 2 weeks, for those who attended the 2 weeks practice, there were 54. Now, sometimes the time doesn't work out so that they can do it in the same year. Now, 41 eventually entered the list. So there's a decrease because some eventually decided not to join the scheme. Now, for 2017, the relevant figures were 93, 45, and we don't have the last figure. But if Mr. Kwok is interested, we can get the data. Just to supplement, on civil cases, which chambers were awarded the cases? Maybe you can collect the data. Now, I think that's easily available. Now, Mr. Ho Kwan Yew has pressed the button, so I'll draw the line. So I hope to stick to 5 minutes each. Next, Lo Wai Kwok. Thank you, Madam Chair. Now, in the discussion document, now concerning the conditions for outsourcing or briefing out, there have been 6 cases. Firstly, expertise required. Suitable in-house counsel not available. And thirdly, the size, complexity, quantum, and length of the case. D is deemed appropriate to obtain independent outside view. And fifthly, a need for continuity and economy. And F, there's a need for advice or proceedings involving members of the DOJ. Now, so people get the impression these are special situations. Now, normally, the government lawyers would suffice, but actually the figures don't show that. You can see that in Annex 1. Now, it's about the approved cases of. Now, in Annex B, now taking the 2016 figures, now at the 3 levels of courts, and then I work out, and for the briefing out cases, now for 2016, now at the 3 levels of courts, 5,383 in-house counsel, 1,911. That's a ratio of 1 to 2.8. So I get a different impression from what's mentioned. Now, I don't know your actual manpower situation. Now, is that a suitable ratio? Now, I'm just asking, now, for the DOJ, how do you regard this, and whether you have a target? Now, so what is the appropriate ratio on the government counsel versus private counsel? Now, this is actually, I was referring to the document prepared by the Legislative Council Secretariat, not the government document. We thank the member for his question. Now, on criminal prosecutions, now, firstly, the prosecutor attends court, of course, and he also has to provide legal opinion to the law enforcement agency. Now, very often, this takes a lot of time, and very often these cases are not suitable for briefing out, except in exceptional cases. So many of the DOJ officers handle legal opinion assignments, such as whether there is sufficient evidence and what charges to charge and what level of court at which to prosecute. And for this reason, now if you look at the number of days at court, there seems to be less for the DOJ lawyers than for briefed out for Fiat Counsel. Now, so should we reduce that reliance? Now, as the document mentioned, in the previous year, we hired 6 more prosecutors. So we hope that would let more paperwork be done, and so that more manpower is available for actual prosecutions. Now, I'd like to supplement now on the number of court days. Now, this doesn't fully reflect the civil work. Now, there is some briefed out work, and a large part is done by DOJ officers. Now, especially work at tribunals and committees, we do that with our DOJ officers. Now, on the civil side, we do almost 100% of the solicitors' work on preparing expert reports and statements and on disclosure. Now, even though we brief out for appearances in court, now actually so actually we focus mainly on the paperwork, and we provide the government departments and bureaus with our legal opinions. So most of this is done within the DOJ, and we also do promotion of mediation work. So that is not briefed out again. So on the civil side, you have to consider those factors in considering the amount that's briefed out. Now, Yong Hoi Yan. Now, I am also on the list of briefing out counsel, although I'm not handling any case now. Now, on assessment, as Mr. Sheikh said, there is not enough transparency. We worked many years, maybe 8 or 10 years, but I'm still on the trial or probation level. So it's rather sad. That counts for me too. Now, I'd like to ask about the assessment and review criteria. I said on the basis of the complexity or on the number of court days. Now, and how much feedback have you given us? I myself received a letter. If you are not able to successfully prosecute, can you explain why is it that you haven't answered certain questions? Maybe you should issue more of these letters to the Fiat Council so that we get the feedback, because I'm sure you have a mechanism to review the cases that we handled. Also, many barristers feel that the briefing out documents are provided us very late. We only get them 1 or 2 days in advance. We may have to handle 5 or 6 cases on a single day, and we have to write out the brief facts and so on. So it's a very heavy workload. and you should tell the police that we need more time so that the process can be speeded up, and so that we can liaise with other law enforcement agencies. And the document says that you would hire counsel of less than 10 years seniority, and you provide a nominal $1,000 fee. Now, how many are there? Can you provide us with the figures? Or is it that in really complex cases that you hire certain counsel? Will you hire more of these younger counsel? Now, I'll answer the second question first, because my colleagues are getting some data for us. Now, on the documents being provided earlier, we think that there's room for progress, and we are discussing with the law enforcement agencies so that the fiat counsels can have ample time to prepare their cases. On the other matter, the third question on training. Now, basically, in the past 2 years, that is 2016 and 2017, altogether there were 41 relatively junior counsel who were trained under this understudy program. And our thinking right now is to see whether the scheme can be expanded to cover more suitable cases, so that more counsel of less than 10 years seniority can serve assistance to more senior counsel in order to gain experience. Now, on selection, now all along we follow up on each fiat counsel doing prosecution work. Now we track their success rate, the number of cases they handled, and other factors. Now,
Ms. Yung asked whether we can provide more details in writing on the assessment. We would consider that. Why would the success of prosecution work be one of the factors for consideration? If you do not succeed, of course it would depend on the judgments of the magistrates and judges. But for a case with very solid evidence, but if the prosecution ends up unsuccessful, then we would look at whether that is related to the performance of the prosecutor. We are not saying that if all the prosecutions are unsuccessful, then the performance would be very bad. This is not what we are talking about. In terms of the prosecution policy, it is a matter of much concern in our society. So for cases involving substantial public interest, are you briefing them out due to a lack of expertise or manpower? There were views that for cases of a controversial nature, you might not want to hold yourself accountable. So that's why you are briefing them out, whether for civil or criminal cases of a controversial nature. So what are the standards adopted by the DOJ? That's the first question. And secondly, I understand that we must provide more opportunities to young counsel or barristers, but having read your paper, I ended up with even more questions. I'd like to ask about paragraphs 13 and 14. For counsel with less than 10 years experience, there would be a token daily rate of $1,000. Of course, the administration of justice is very important, but in that case, are they treated like trainees? We are talking about sensitive cases that are also complex. If that is your policy, I'm rather concerned. And in paragraph 14, you talked about civil cases. You talked about their diversified nature and complexity. I understand the reason for briefing out cases. Well, in public hospitals, well, you are just offering $1,000. I don't know how the public would perceive of administration of justice. So can you please answer those two questions? Chairman, I would first take the first question. On the briefing out of criminal cases, generally, if briefing out is necessary, very often it would be due to a lack of manpower or expertise. You mentioned certain views that we don't want to hold ourselves accountable, and I want to stress that this is not a factor of consideration. Whether or not the prosecution is successful, the jury and judges would be the ones making the decision. For cases of major public interest, they would often drag on for a long period. And in those cases, we would have to consider manpower. In most cases, for cases briefed out to local or overseas counsel, at least one of our officers would serve as understudy. Yes, I understand that you are understudies. I'm talking about responsibility. Of course, at the courts, the jury and judges would make a decision, but if you decide not to prosecute, it is a significant decision. So for important cases, shouldn't the DOJ make the decision? So that's why I asked whether it's a lack of manpower, expertise, or you want to dodge the responsibility. You are only understudies, but the DOJ has an important role to play in the society. Of course, I agree with that. For important cases, if we have enough manpower and expertise within the division, well, so is this about a lack of manpower or expertise? The manpower position is generally short because in a number of cases at different levels of court, fiat counsel are needed. For example, district courts, court of first instance. So we would try to deal with those cases, but if our manpower is exhausted, we would need to brief out cases. For certain cases, they would be briefed out due to a lack of expertise in-house. Chairman, you talked about situations in which no prosecution is taken out. Whether we hire counsel, senior counsel, or overseas counsel, the legal advice received just legal advice, and the ultimate decision is vested with the DOJ according to Article 63 of the Basic Law. And we would make an independent and professional judgment. Are you the one making the ultimate decision? It would depend on the level of the case. For most cases of an important nature, of course, I would take part. Ms. Holden Chow. Thank you, Chairman. First of all, I'd like to thank the DOJ for offering the detailed explanations. I'm confident in the DOJ's professionalism and judgment, as well as independence, and I have great faith in that. For ongoing proceedings, for example, the instigators of the Occupy movement, some have been prosecuted, some not. I would not dwell into these because there are ongoing proceedings. I want to talk about cases or incidents that have already concluded, including the so-called political donations under the table made to Legislative Council members. They were not declared, and they caused a stir in our society. Earlier, the DOJ made a decision to not prosecute the persons involved. Since this incident was concluded, I'd like to ask that for these important cases that have concluded, can you tell us whether fiat or in-house counsel were deployed? For important cases or major cases, have you obtained independent legal advice before you made your decision? So this case has ended, so I'd like to seek an explanation. Director, thank you very much. Generally speaking, of all the case mentioned, as I remember, the DOJ offered a detailed statement on why we felt that there was no chance of conviction according to the prosecution code. So I would not repeat what's been said in that statement already. But to answer Mr. Chow's question, would there be cases in which we sought legal advice from independent fiat counsel? And for the case mentioned, the answer is no. But as to whether we seek independent legal advice for each case, it would depend on the scenario and legal principles involved in each case. In our analysis on why we felt that there was no reasonable chance of conviction, in that case, there was a similar case earlier, and at the end, there was no conviction. So that was one factor of consideration. Dr. Junius Ho, thank you. The director said there was no reasonable chance of conviction. Well, I had a letter asking the same question. Apparently, it has no direct relation to this item. I will follow up on that next time. So you said there was no reasonable ground. So what would be a reasonable one? I would like more details. First of all, on the ground. For that case and the other cases we are talking about, I think they are not comparable. So I'd like to know how much weight that factor carries with external or outside legal advice. According to 23.4 or 23.2 of the Prosecution Code, in cases that involve major public interests, I hope you can elaborate the reasons in detail, including the jurisprudence offered by the Fiat Council. And I'd like to know the weightings of such compared with the evidence of the case. With regards to the Fiat system, in the annex of your paper, paragraph 17 or paragraph 7, in 2016 to 17, you talked about payments for non-standard briefing out and standard briefing out cases. The figures have changed drastically over the years, and details are in Annex B. In 2016, the payment for briefing out of cases or standard briefing out was 95 million, and as for non-standard briefing out cases, about 35 cases. So I'd like to know how much the most expensive brief was. And in Annex A, the figures were astonishing. For cases briefed from the 14th of November 2016 and onwards, and the brief fee was 49,000 for this Court of Appeal and about 36,000 for Court of First Instance. While Mr. Philip Dykes is here, he charges $300,000 to $500,000 for a judicial review. So if you only pay 40 or 30,000, how can you expect anyone to come? So the fees are certainly unrealistic. As for the fees for non-standard briefing out cases are about 150% of standard cases. I think you have done something, but this is not enough. You listed 6 reasons for briefing out, but in terms of the assignment of counsel, would the utilization of solicitor advocates be raised, for example, especially at magistrates' courts or district courts for the 500 or 1,000 cases? How much work is taken up by counsel? Mr. Leung? I'll try to address the first question in terms of the figures. He talked about the year 2016 for the payments for standard briefing out and non-standard briefing out cases and the number of cases handled.
Now, you can see that in the documents we provide every year. Now, for cases of over $1 million spent, now we classify that into civil, criminal, and construction dispute cases. So the data are available. You can see the details. Now, I drew the line just now. Now, I'd like to give a little more time, firstly, to the DOJ side and the representatives of the Bar Association, either Mr. Dykes or Mr. Shek, to see if they have further comments. Please be brief. Ho Kwan Yew. Now, can they provide a written response to my questions just now? Mr. Ho asked a few questions, so please try to comply. And so final supplements. First, the legal officer or the DPP, Any supplements? Even for my questions, I feel that you didn't provide very direct answers. Now, if you say you have insufficient manpower or insufficient expertise, now, should we discuss to see whether we should provide you with more resources so that you can hire the talents that you think you require? Now, you don't have to avoid the issue, so we'd like to hear about that. Any supplements? A brief supplement. Now, within the DOJ, especially on the prosecution side, very often we cannot control the requests from the law enforcement agencies. Now, very often crimes are evolving all the time, so we do need more time. And as I said, we hired 6 more prosecutors in the past year, and we'll try to hire more in the coming year. And as I said in my earlier briefing, now we do need to raise the quality of public prosecutions. So we will look closely at the manpower. And I understand that the public is concerned about briefing out situation. Of course, firstly, we do need to brief out when necessary, and we will try to strike a balance. Now, where we can, we try to provide opportunities for more junior counsel who are interested in prosecution and litigation. Now, as for fees, of course, we will actively consider a review, whether it's the understudy program, the level set in 2011, and Ms. Yong and Mr. Shek also mentioned, as they mentioned, the current fee level, whether there is room for further increase. Now, this isn't just to be decided by the DOJ. Now, on the principle of fairness, the briefing out fee scale and is linked to the legal aid department fee scale, so it's not entirely just up to the DOJ.
Well, I'd like to assure Dr. Junius Ho that I'm very flattered by his estimates of my professional worth, but you will not find those kind of fees being paid by the Director of Legal Aid during immigration judicial reviews. Having heard the discussion and the questions raised, I just repeat the main concern that I have is that the DOJ saying it has established guidelines which are internal to ensure, quote, propriety of the process and avoid any possible favoritism. There is a case for having those made public. Like I've said, you will find the websites of the Crown Prosecution Service and the English Attorney General details which will be very valuable to practitioners to know where they are, how they stand, how they can progress. And that will in turn ensure that public money for which the DOJ is accountable is being spent and is being seen to be good value for money. And I emphasize again, it must be made clear that when selection is made, it's based on merit only, and there is no discrimination on grounds, as I said, of religion, disability, political affiliation, etc. And I would like to have the DOJ confirm that that forms part of its internal guidelines, because, as I said, people at the bar have the conception that is not the case.
Okay. 石大律師。
我有2點係想喺呢一個機會係補充嘅。第一就係關於民事外判嗰方面呢，就剛才我聽到專員提及過，就譬如話即係考慮到案件嘅複雜程度會牽涉到譬如憲法公共政策嘅問題。咁其實據我嘅了解呢，其實民事嗰方面呢，其實亦都有好多唔需要牽涉到咁複雜嘅議題嘅案件嘅，譬如有好多唔同嘅紀律委員會都係會牽涉到民事嘅外判大律師。咁我自己亦都有一啲同我差唔多年資嘅同行有提及過，佢哋已經係喺律政司裏邊上咗 list 啦，所謂民事個 list， 即係已經係幾年時間，但係從未有一次係
list for several years, but they haven't once been assigned for a civil case. Now, just now, the question was asked how many cases went to the respective chambers. Now, as Mr. Dyke said, this is a matter of concern to our profession because we see which cases how many cases went to certain chambers. So if you can provide the data, the figures, I think this would be very helpful. Second point, Mr. Lo Wai Kwok mentioned about Appendix 1, the fiat cases and the court days don't quite seem to match. Now, looking at the number of cases handled by fiat counsel, mostly they are in magistrates' courts. But at DC and CFI, it's the government lawyers to take up these cases in most cases. This is understandable because at magistrates' courts, the cases are more simple but more numerous. At DC and CFI, the cases are more serious and more complex. So for the DOJ to employ its own lawyers, now that's reasonable, but there should be more opportunities for fiat counsel so that they can graduate from the magistrates' courts. And court days, there is a big difference. Most of it went to fiat counsel, but when cases go to fiat counsel, mostly is a trial stage, and the number of days is hard to control. And when they engage in such court work, they cannot do other work. So Mr. Low looked at the charts and raised this question, so I hope to provide a perspective. Now, the chart shows, in fact, it doesn't show that excessive amount of work went to fiat counsel. Rather, it shows that at different levels of court, different proceedings, there are different needs. Now, today has been very fruitful on a number of issues. The views of the professional bodies and of members have been aired. Of course, we cannot cover everything. Now, 5 minutes each member, and there are many issues involved. And I hope in the future we have more opportunity for such discussion. Now, on my second question, only $1,000 per day, I think that's really too low. Now, if it concerns legal aid or other matters, I think the panel will follow up, and perhaps the DOJ can provide us with a little more information, because this involves prosecution policy. And we want the fiat system to appear more reasonable. Not everything should be outsourced, but now we are not focusing on resources today, but I think you can go back and give us a more complete picture on whether you need to hire more people and to provide more experience to your own officers, and also to also for Fiat Council to provide more reasonable fees, because we all want to improve the quality, whether it's within the DOJ or among the Fiat Council. It's for the good of the whole society. So we finished discussing this item. We thank the law officer and the DPP. Next, we will immediately go to discussion on what we have been follow up for quite a while. That is implementation of the Law Reform Commission of Hong Kong report on hearsay in criminal procedure evidence amendment bill 2018. Now we invite the officers to enter the chamber. The legislative document is CB 619 70 to 18 bracket 05. It's a document prepared by the administration, and also bracket 06. That's the one by the legislative secretariat. Members can press the button if they wish to speak or raise their hands. Right now, we first invite the government representatives to speak, and then we will also invite from the Bar Association, Mr. Philip Dykes, Senior Counsel, and representative of the Bar Association, Mr. Randy Sheck, to air their views. Now, first, is it Mr. Leung who will? It will be Mr. Peter Wong, Deputy Solicitor General, Policy Affairs. Now, just briefly, now, last year, in April to July, we undertook a detailed consultation on implementing the report, and we received many valuable views, including those from the two professional bodies, and we provided a detailed report in the annexes. And on the implementation of the report, we discussed thoroughly and prepared thoroughly. In 2012, we came to the panel to brief you, and we got the message that we should handle this carefully.
It would affect the role of hearsay in criminal procedures, so we had a very detailed consideration or discussion. We came up with a fair framework on the right to equal access to proceedings, and we want to protect the parties involved as well as victims. So that is the idea of our framework. In the paper, we talked about the background of hearsay, and that is the use of the argument. The major argument is that the use of hearsay is that the declarant cannot be examined, so that is the major constraint. So we must make sure that evidence before the court, even if it's hearsay, must be reliable and necessary. So that is a so-called necessity condition and threshold reliability condition. There is some complexity to this. So apart from the core scheme, we would look to reform the entire system on hearsay. And in paragraph 5, we talked about our consultation paper, and it is attached at annex. It also mentions some concerns on human rights. Apart from the protection of human rights, according to the LRC report, there are updates which confirm that our current proposal can satisfy the International Bill of Rights and the enforcement in Hong Kong. And in paragraph 6, we mentioned the views received, and in general, they are supportive of the proposal. And some content would be further improved. My colleague, Ms. Lam, will talk about the details. For the summary of the legislative proposals, they are listed from paragraph 7 to 11. And for the necessity condition, means that hearsay would only be used if necessary, and the condition is satisfied only if the declarant is dead, is unfit to be a witness because of the declarant's age or physical or mental condition, C is outside Hong Kong, and it's not reasonable, practicable to examine him or her. A fourth possibility is that the declarant cannot be found through all reasonable steps. And finally, we have excluded the ground of self-incrimination as a reason for the declarant to refuse. And in paragraph 8, we explain that if the declarant leads to such end result, it cannot be used as a defense. As for the condition of threshold reliability, we feel that not all hearsay can fulfill the necessity condition. When we look at the relevant human rights judgments, necessity and reliability are important conditions. So we listed 5 key elements, and the court must have regard to A, the nature and content of the hearsay evidence, B, the circumstances in which hearsay was made. For example, if the hearsay itself is contradictory, it might be a reason or a factor to consider. For example, the timing for recording the hearsay, if it's made after a very long time, the reliability might be in doubt. For instance, if when observations were made, were the surroundings dark, so all these would be taken into account. So there are also safeguards which would ensure a fair trial. Under the bill, the court must ensure that the conviction would be safe. They have to consider the importance of hearsay to the entire case, etc. And with the views of the 2 legal professional bodies, since it's impossible to examine the declarant, this would be one factor of consideration. The court might order that proceedings be ended. So the necessity condition and condition of threshold reliability, as well as the safeguards, form the cornerstones of our proposals, including the court's power to end proceedings, to facilitate administrative justice, or prevent unsafe convictions. As for the bill itself, we aim to optimize certain aspects. Ms. Ho, Chairman, members, good afternoon. From April to July last year, we carried out consultation. We consulted the judiciary, legal professional bodies, relevant law schools, and concerned groups, and we consulted their views. We received 11 submissions, the most of which supported the proposals. In particular, the Bar Association and Law Society offered valuable and detailed views and recommendations. After considering these views, the DOJ consolidated them in Annex 3 of the paper. We have drawn up a table with the summary of views and suggestions and the DOJ's response. And I'd like to report that at this stage, we are going to accept views on 5 issues or aspects. First, on 55E and G of the bill, there were calls that our wording is too clumsy and it should be simplified, and we accept that. So we would streamline that. And the second issue is on 55M, Section 55M of the ordinance on the admissibility of evidence. We used the word leave in the English version. We would change that to the word permission, and the Chinese will become 准許 from 許可. For 55N and brackets 3, brackets A, we would clarify that if a party does not serve notice of hearsay, the court would have the power to order litigation costs, and this is regardless of or irrelevant to the outcome of the case. For Section 55P, items A to E, we clarify that these 5 are factors that would dictate whether the hearsay satisfies the necessity condition. And the 5th issue is Section 55Q brackets 4. We would make it clear that the lack of examination would be a factor the court would in making its final decision. Thank you very much. We now invite representatives from the Bar Association, Mr. Fifsteig and Mr. Randy Shack. Would you like to speak?
To Mr. Randy Shack on this matter. I go back into this rather late in the day.
Okay. 咁啊，請石大律師。
Mr. Shack, please. The bar has provided a submission to the DOJ on this issue and our position. As for the legal reform on hearsay, our focus is on the protection of rights of the accused. If hearsay is accepted, or has a possibility to be accepted, would the details of the information be provided to the accused so that he or she has a chance to offer a defense? And this is important. Under this bill, there are different safeguards However, how can these safeguards protect or cover proceedings that are already underway? And if the court admits hearsay, would the defendant has enough time to launch a challenge? And there are still some doubts on this. And we have already made our stance very clear in an earlier submission. Thank you very much. So apparently they have taken some of your views on board. 4 members are waiting to speak. 5 minutes each, please. First up, I'll read out the names. Dennis Kwok, Fernando Chang, Holden Chow, and myself. Mr. Dennis Kwok. Thank you, Chairman. Chairman, I'd like to say that we are highly supportive of a reform on hearsay.
Now, the Solicitor General will remember that we urged the administration to look at the issue, and the administration provided a timetable that this should be passed in the current legislative year. Now, previously, we went to the Secretary of Justice, and Dr. Fernando Cheung attended to, and I'm sure you know which case spurred us to look at this reform. And I remember that the criminal committee, cases committee of the Bar Association had certain reservations, but hearing from Mr. Sheikh, now, is it that after the law is now proposed to be changed, have you withdrawn your reservations? Now, concerning our previous reservations, now, for our criminal cases committee, what are their views? Now, I cannot tell you now because we just undertook some elections, and the committee is now being formed in the preparation stage. Now, so apart from the consultation feedback that we provided previously, we haven't yet had the chance to hold meetings on the latest position. Now, I invite your committee to try to look at the issue as quickly as possible. If you have reservations or other views, try to provide them to the DOJ and to us as quickly as possible so that we can consider that in an early stage in our legislation. Certainly, it would be within the next 2 to 3 weeks. I have no further questions. Next, Dr. Fernando Cheung. We welcome very much the proposed legislative amendment on hearsay. Now, as Mr. Kwok said, after the Cambridge case, we are very concerned, and with this proposed reform, the hearsay evidence will stand a chance to be submitted, and justice can have a better chance of being done. Now, we believe this is a moderate change. Now, looking at other jurisdictions, they have similar arrangements. Now you have the necessity and reliability threshold criteria, and there are other safeguards at court, so I think it's quite sound. Now I'd like to ask, now maybe I'm not an expert. Now, under current law, now, apart from evidence by other persons, there might also be video recorded evidence. Right now, for these videos to go to court, it must be with BRI were conducted by social workers, police, and so on. So for these video recorded interviews to be submitted in the future, do they have to follow this format, or can there be other modes of evidence where these government personnel are not involved in such video recorded evidence? Can they also be evidence accepted at court? Now, of course, in the other jurisdictions, the simple answer is yes. It depends on the case. The quality of the evidence has a lot to do with reliability. Of course, if it's a video recorded interview, of course it raises the reliability. The victim or the witness doesn't have to appear in court. Maybe he or she has died, so we must rely on hearsay. Otherwise, we would use existing legislation with regard to these VRI. Now, and the Bar Association mentioned whether there would be certain improvements in disclosure. Now, in our document, we say that there are different standards that have to be reached. One is balance of probabilities, and the other is beyond reasonable doubt. So we will apply the same criteria that we've been using. Mr. Hui, the Deputy Director of Public Prosecutions. Now we thank Mr. Shek for his question. This is has a lot to do with a major direction of our reform. It's a broad reform. It's not just targeted a certain type of crime, such as sex-related crimes. It's also related to other criminal proceedings. So we draw on existing principles and prosecution guidelines. Now, one relevant issue is the responsibility for disclosure, and I can assure that the panel that we will make sure that the information disclosure by us will be timely and complete. Can you provide us a timetable after this discussion? When will you present us with a bill? Now, after today's consultation, we expect that we will further improve the wording, and we expect that by the middle of the year we will present the bill. Now, we have to go through certain internal procedures, but we hope to come up with present the bill by the middle of the year. Next, Mr. Holden Chow. Now, before he speaks, now we have only 6 minutes or so left. So I now announce we have to extend the minutes by 15 minutes. Mr. Chow. Thank you, Madam Chair. Now, first, I welcome the proposed amendments on hearsay. Now, in the past, there was this tragedy of Cambridge incident. Now, the victim at the time was mentally incapable of attending court, or attending court would do a lot of damage to that victim. So justice was not done. Now, this current reform should help resolve that problem. But on the other side of the balance, I like to ask. Now, I note that Bar Association asked the same question. Now, in your annex, in paragraph 8, it talked about necessity has to be on certain conditions, and in paragraph C, it mentioned that if the declarant is not in Hong Kong, is outside Hong Kong, and it's not reasonable to expect him to be present, and it's not reasonably practical to make the declarant available for examination, etc., then these would be the criteria for accepting hearsay. Now, we understand that after the reform, we, of course, for the defendant, you have to afford him or her a fair trial too. Now, in the past, we say that you don't attend court, what you say cannot be evidence. Now, that's the principle before, up to now. So now I ask, now the declarant is not in Hong Kong, you cannot assure that he can be reasonably expected to appear in court. Now, for the defendant, now he certainly hopes that the witness should appear in court to accept cross-questioning. But you now say he's not in Hong Kong, he doesn't have to be a witness in court, and yet his evidence can be accepted. So would that be unfair? So can the administration explain? We thank Mr. Ho for his question. Yes, we like to apply the criteria very strictly. The witness couldn't come to Hong Kong. Now, that may not be enough. We have to see whether there can be some electronic means of questioning. Perhaps we can reach some agreement with the judiciary in the other country, and only when that cannot be done would we employ the new mechanism. Sorry, can I follow up? Sure. Now, if, as the administration explained, all the means have been exhausted, so the necessity criterion is met, but actually, that person is trying to evade you by all the means available to avoid coming to court to testify. And he knows about these new rules, so he finds a way to not to have to come to court, and yet he can make certain declaration to the disadvantage of the defendant. So how do you deal with that? The DSG? Now, practical steps, reasonable steps must have been taken to find that person. And only when that person cannot be found, even after those procedures, will they apply. Now, if the prosecution witness is not cooperative, he may have tried to avoid appearing in court by various means, then the original rule may apply. Now, my question, let's be more direct. Now, on the hearsay issue, now we are interested because we are concerned because of the Cambridge incident. I'd like to ask the administration, now you are proposing this bill to amend the legislation about hearsay. Now, it's now hypothetical. The person may be incapable in his ability to act. So are we now providing a channel for such situations? The declarant doesn't have the capability. I hope you can address the public's concern. Is it that after this amendment, in that type of cases, there can be follow-up that was not available before? Yes, the purpose of the reform is for justice to be done. There have been cases where the declarant could not come to court, and his evidence then is hearsay evidence, and yet is necessary and reliable, especially in sex-related crimes involving young children. Maybe the child lodged a complaint to the parents, but the child could not come to court. And the complaints are actually quite reliable, and there's no reasonable doubt to question the reliability. But in the past, we couldn't make use of hearsay evidence. Now, that's one case. Now, the DSG also mentioned that there are different types of cases, apart from sex cases. In UK, for instance, there are cases of robbery, murder. Now, the declarant may have died, and with the new reform, we can handle such cases. Now, I'd like the public to get a better understanding. Now, you couldn't do it in the past, you can do it now. Now, where is the main issue? Now, and the Bar Association also dealt with this. Now, can you speak in more detail? Now, how would you be able to deal with cases like Cambridge now? Now, I wasn't directly involved in the Cambridge case, but
for murders, the relevant witness has passed away, even though he or she might be a key witness. The relevant accounts have been given to the relevant officers, but since the declarant is no longer alive, he or she can no longer give further accounts. So this would be one of the applicable examples. In cases in which the witness cannot be located, or if the witness is no longer mentally capacitated to do so. So for witnesses and victims at witnesses, they can benefit through this reform. But we are aware that the reform would also affect the defense. The declarations might help the defendant, but because of hearsay, it might no longer be useful. For example, a witness might recognize a person of a certain race when in fact the defendant might be of another race. So in that case, the hearsay might benefit the defendant. So it goes both ways, but at the end, the goal is still to administer justice. So, Mr. Shak, the bar has expressed their views a number of times, and they have spoken repeatedly to make sure that the defense would not be put at a disadvantage. The director felt that both sides can benefit, but of course our standard would be beyond reasonable doubt for the defense. And there are certain trigger events in Hong Kong. Could your doubts be alleviated? We are not talking about automatic convictions because the judge would look at different things. Your past representatives were very experienced in criminal cases, but I see that they wrote that or they said that the defense should not be put at a disadvantage. Since we offered our views last time, a lot of arrangements have changed according to this paper. And I think we have already struck a right balance. So personally, I have no issues with it. But on behalf of the bar, since we have not put this committee in place yet, but based on past documents and the current proposal, personally, we have to strike a balance between public interest and the rights of the defendant. I think we are doing a pretty good job in striking a balance. Thank you very much. Hearsay is of much relevance to the public, and we understand our principles all along on hearsay evidence, and we are going to have a reform, and hopefully the changes would be positive to everyone, whether to the victim or accused. We hope that this can facilitate justice. The panel generally supports the amendments. So if you are to come to LegCo again, perhaps within the quarter we will follow up on that. Thank you. I'd like to thank everyone. We've had a fruitful discussion, and the next meeting will be held on the 26th of March. Thank you.